So we're all set. Hi, everyone. Thanks for taking the time to join us today for a session on intellectual property considerations for entrepreneurs and startup companies. My name is Lisa Armstrong. I'm the Associate Director here at the UMass Lowell Innovation Hub. And also on this call is my colleague, Stephanie Guyette. She's the Associate Director at the Innovation Hub in Haverhill. And also on this call is our boss, Tom O'Donnell, Senior Director of Innovation Initiatives. For those of you that are not familiar with the Innovation Hub, we're an incubator supporting entrepreneur and startup company success via co-working space, private offices, a prototype lab, and as well as the use of conference rooms and event space. We offer our members in the community valuable programs and workshops like you're going to see today. Hopefully one day we'll be able to meet again in person and have everybody here at our facility, but for now it's nice that everyone is connected. Both iHub locations are open, and we take the health and safety of all of our members seriously, and we're enforcing the use of masks, social distancing, and thorough cleaning and sanitizing. If working at home is no longer ideal or not an option anymore, we invite you to reach out to us and then join us here at the Innovation Hub. And if anyone wants more information, please reach out to Stephanie or myself during the call. And also to note, as an attendee at this event, you'll be added to our email list so that you can hear about future events happening here. Presenting today's session will be three attorneys from Schmeiser, Olsen Watts. I'd also like to thank this law firm for being a sponsor of the Innovation Hub. We appreciate your support. And now I will pass the virtual mic over to patent attorney Tim Collins.
Thank you, Lisa. Hopefully everybody can hear me here. So I'm going to bring up a presentation that my colleagues, Vic Baranowski and Ali Scoville will be assisting me with. So we have a lot of material we're going to cover. The way we're going to handle this is we're going to present give this slide presentation, which will run about an hour, and then we'll follow that up with a Q&A session. So if anybody has any questions, they can use the chat feature of this Zoom call, and our colleague Rachel Rosenblum can collect them, and then we'll address those questions at the end. So to start out here, let me just get to the agenda here. So the first thing we're going to cover is, and that's why most of you are here, is to understand really what intellectual property is about, the value it offers to you, specifically as if you're a startup company or an entrepreneur. And then we'll talk about the types of intellectual property. Vic will describe the details of that, of each of the major components of intellectual property. And then at the end, we'll talk about ways to control costs, manage costs, while still having an intellectual property strategy. So as I mentioned, we have a lot of material to cover, so I'll get right into it now. The value of intellectual property. So the question is that everybody asks is, what is the value of intellectual property? And I'd start out right at the beginning by giving you the classic lawyer answer. It really depends. There's so many different factors, and we'll just touch the surface here as we go through this. But first and foremost, intellectual property is an asset. It can be interpreted by investors, buyers, anybody. If you're interested in an exit strategy, it could be analogous to your computers that you've purchased for your business. It is an asset. Investors want to monetize intellectual property, so there are valuation exercises that can be made on your patents, your trademarks, and so forth. And then, as many of you have known, if you watch Shark Tank, for example, patents and trademarks, copyrights, and so forth are often a prerequisite to receiving that initial funding. Even as you're going forward, investors are going to want to see what you're protecting. The primary benefit of intellectual property is to prevent competitors. I use the word illicit actors, but it could be anybody. It could be somebody in another country that's trying to steal your not just your invention, but your code, your software code. And we all hear the horror stories about what happens when people break into your computer to do that. It's happened to my clients, and it's pretty horrifying in many ways. And so the other final part of that is forming an IP strategy that is unique to you, but also allow you to execute it according to a tight budget. So we'll cover a lot of that at the end of this. At a very, very high level, the major forms of intellectual property include patents, which are intended to cover and protect your invention. It could be an improvement to something that's existing. And the legal definition is, and this is true, that it's anything under the sun made by man. So that should speak for itself. Trademarks are intended to cover your brand names, your products. They are products. They are brand names. I'm sorry, but they could be designs. They could be something that identify with a particular product. You know, when you see the Mercedes symbol on the hood of a car, for example, that could be a trademark. If you see the Nike swoosh on a shoe, that's an example of a trademark. And then copyrights are intended to cover. They could cover your software, but they could also cover books, photographs, music, and so forth. And then trade secrets are intended to cover information that you can actually protect, that you can actually hide. For example, the formula to the secret recipe to the Coca-Cola drink would be an example of a trade secret. So we'll cover those in more detail. I'm going to turn this over to Vic now, who will talk about the patent piece of it.
Yeah, thank you, Tim. Yeah, my name is Vic Baranowski. I'm a patent attorney at Schmeiser, Olsen Watts, and I specialize in patent prosecution. Although I have experience in all forms of intellectual property, my expertise is in writing patents, counseling clients with respect to their patent portfolio, and dealing with the United States Patent and Trademark Office to obtain patents for our clients. So what we're going to talk about today, we're going to go into detail about patents and try to just give you a broad overview in the course of about a half hour, maybe a little bit less, of what a patent is, and answer some of these particular questions that we have right here, which is what's a patent? Do I need one? And what are the types of patents? There's different types: provisionals, non-provisionals, design patents you might have heard of. So we're going to go into some detail there. What to expect after you file your patent application. We're going to talk a little bit about the difference between when you file your patent application in the United States versus international protection. We're going to go into, okay, what happens once you finally get your patent? What does that mean? And then finally, just some expectations about what you should expect in the process, and also from your attorney. You can move. Okay, so what is a patent? As Tim alluded to, really anything under the sun that is made by man can be applied for. But really, there are three requirements. One is that it's one is that it has to be new and never have been done before in anywhere in the world. So that's not a national, like, U.S. requirement. That's if it's been found to have been done anywhere in the world, then it's not eligible for a patent. It also has to be useful and not obvious. And the usefulness requirement sort of distinguishes from copyright law, where copyright law is a creative expression that might not have utility in the same respect as what a patent is required. But really, what a patent protects is it protects these concepts, your new ideas, your inventions, by preventing others from making, using, selling, importing, etc. So what we mean by that is it doesn't necessarily give you the right to practice the invention. For example, if you invented a new drug that was brand new, and somebody and you created something that quite possibly was new and might be useful, it doesn't necessarily mean you have FDA approval to practice it. And so there might be other things that would prevent you from doing so. But the actual patent grant itself is what it gives you is the monopoly to prevent others from doing that. And in most cases, you are able to practice it yourself. The other thing is this is a sort of a quid pro quo process, unlike trade secrets, where trade secrets you keep it to yourself. But in this, you're required to disclose it, and that's what a patent is when it issues, is a disclosure to the world that this is your invention. And so here's so who can receive a patent? And anybody can. And as you can see here, Abe Lincoln, and there's been many famous patents from famous people that you wouldn't think about being as inventors. And these are a couple examples. Eddie Van Halen for musical instrument support. What are some of the reasons that somebody would want to get a patent? One would be to deter others, obviously, and try to hope that once they know, again, you're disclosing that you have the patent, your patent is out there. People in the industry are expected to review the patents in their industry, sort of, and hopefully that deters others from even wanting to go down the road of trying to do what you're doing. But there's other reasons too. For example, generating a portfolio for the purpose of investment or acquisition. Obviously, Tim alluded to, these are all assets that we're creating for our company, and investors are interested in making sure that you have your IP protected. It also is sort of this leverage game against competitors, because you might have a patent yourself on a product or a process or an invention, and your competitors might have a product patents themselves. And once you get into this competitive situation, sort of sometimes you're in this like nuclear standoff where you have patents, your competitors have patents, and that's the reason that no lawsuits are happening and people are continuing because you both have patents. If you're on the end of the stick without the patents, then you might be more inclined to be sued for the types of things that you're doing in a competitive industry. Generating licensing revenue is another form of a reason that you would want to get a patent, because once you have the patent, you can license that out. But it's also used as both a sword and a shield. So what we mean by that is, from a defensive sense, you can discourage others from trying to do what you're doing, and ensure that you can do what you want to do. But you can also enforce the patent as a sword against your competitors if they are in fact infringing. You can keep going, Tim. So other considerations about when you're deciding whether you need a patent would be the cost of filing and the patent, which really there's a big range here that we see, and that depends on complexity of the idea. It also depends on the difficulty in obtaining the protection and the arguments and the process that it might take to actually obtain the patent at the United States Patent and Trademark Office after you file it. So it's both the preparatory costs are pretty significant. These patent documents we're going to go into it a little bit. If you've ever seen a patent before, all of that work has to be done to create that document. But also there also has to be argumentation to argue with the patent office oftentimes to actually obtain the patent. And so you're also considering, though, if it is in fact an idea that would be preferably to be protected via a trade secret instead of a patent. Patents have a quid pro quo that lasts, that monopoly lasts 20 years, but it does eventually expire. There's also costs associated with obtaining a patent, whereas a trade secret, if you're able to keep it secret, the costs are associated with keeping the secret but not paying legal fees. And trade secrets could presumably last, forever, or much longer than the 20-year period, as long as you're maintaining the secrecy. But also, just how valuable is the idea? You have to weigh the costs associated with maintaining the patent with the benefits that you're going to get for having that monopoly and having that asset. So one other consideration as well is I wanted to talk about briefly is non-disclosure agreements. So in some instances, well, you want to try to get a non-disclosure agreement before you file your patent application, in place with anyone that you disclose your idea to, because prior to filing your patent application, you have a 1-year window after for once you disclose your idea publicly for when you have to actually file your patent application. So that's something that we run into oftentimes with inventors, is that they don't realize that there's a 1 year window and they've disclosed their idea publicly in a very public way prior to 1 year. And what is a public disclosure? That's pretty getting into the weeds. We can answer more specific questions about that. But basically, you want to get NDAs in place, especially before you file your patent application. And it's generally customizing. It's generally a good idea to get an NDA in place even after you file your patent application, and when you are pitching your invention to others. However, it's better when you're pitching investors in large companies to have patent protection already in place, because oftentimes investors in large companies are not interested in signing an NDA, but that's not because they're trying to steal your idea. That's because they really they get pitched by many people, and they don't want to be under contract with every single person that pitches them a concept. So we don't discourage our clients from talking to people that are looking to invest in their idea if they don't have an NDA in place with them. But it is still a good idea if they will sign it, but we don't discourage it if they don't. But we do want you to have that patent in place prior to those conversations. Patent application in place. So we have 3 different types of patent applications that you might want to file depending on your circumstance: provisional, designs, and non-provisional. And we're going to go into a little bit more detail into each. So a design patent is based on protecting basically the look and feel of the look of the design of a concept. And so it's generally much less expensive to file, but you do need to get very, very good and you need to basically every possible view of the design shown. And so while it's less expensive, it could be very powerful. And the standard is whether you infringe a design patent is whether the design in the patent. You can move on to the next slide, Tim. But whether the design in the patent is substantially similar in the eyes of an ordinary observer, and that's sort of the standard. And so you claim your patent. Actually, you can go back one real quick just to show that picture. This is an example of a patented design on the left, and then you have and it's designed for the sort of the end piece of a utensil fork. And so you have a couple of designs that were accused, both the accused designs that were found to be sort of substantially similar in terms of the end of that fork. So that gives you an idea of what you're looking at from a design patent and whether it's substantially similar in the eyes of an ordinary observer, not an expert observer. And that's how you would essentially assert a design patent. Okay, now you can, yep. So provisional patents is a form of a patent protection that's sort of, it's what it sounds like. And so it's basically, it gets you, it's a preliminary submission to the patent office so that the patent office puts your invention on file and basically it stamps your foot into the ground, or dig your foot in the ground as far as the date in which the patent office will accept the submission, and you will preserve that filing date, which is important for establishing, what your filing date and your patent pending date. So you are patent pending with a provisional, but you have it's not a full patent application in the fact that it will not be examined until it's converted into a non-provisional. It will never turn into a fully granted patent until it's converted into a non-provisional within the 1 year date. And so that you eventually need to file that non-provisional. You eventually need to do all of the things that were not necessary in the filing provisional, like obtain formal drawings, like do claims. We're going to talk about all of those things that are more formal, the formal requirements of the non-provisional. But because there's less formal requirements, it actually is a much less expensive form of patent protection. And so and you do obtain the filing date, but you do want to be a little careful in making sure that you do disclose your entirety of your invention when you file a provisional, because if you file a provisional application that is not well described, you're only afforded the filing date for what is actually described. So you want to make sure from a descriptive sense that the inventive concepts and the wording that you want to use to describe the invention in your non-provisional is pretty fleshed out as much as you can possibly do at that stage. And so but the reasons you file that first instead of just going straight for a non-provisional is that it's going to defer cost. There's going to be you're going to quickly be able to file it with, again, less formalities. You don't need to have formal drawings. The patent office is going to accept whatever you file, and so it's giving you a filing date for whatever is in there. And then you're able to extend back 1 year from that filing date, assuming you wait that whole year to convert into that non-provisional. You can defer costs up to 1 year because the non-provisional costs are going to be much more expensive. And that gives you 1 year to basically make that determination if you want to add those additional costs to convert it and eventually obtain your patent. You might decide it before that 1 year is up that it doesn't make sense for you to proceed. So again, this kind of goes into some of those what we just discussed, but there are no formal requirements, which makes it less cost. You are patent pending at the time of a provisional. The USPTO accepts it. It will not be examined until it's converted into a non-provisional within that year. And if it's not converted, it actually never gets published by the USPTO if it's not converted within a year. The USPTO just has it on file, and it's not considered a public disclosure. So if you haven't publicly disclosed it, you're not starting that 1 year statutory trigger for your patent to be invalidated based on a public disclosure. But again, you want to make sure that you have as much description and completion in terms of explaining the invention as possible, because if you're going to add a lot more to it by the time you do the non-provisional and you create that fully fleshed out application, which again we call a non-provisional, that within that year, if you're going to add information, what's going to happen is the new information is not going to be given that filing date. So you only get the filing date for your foot in the ground for what you actually file. So again, this is the non-provisional application. This is what you would convert the provisional to. This is the formal one that's basically in contrast to the provisional. And this is what you're eventually going to. These are the application that looks like the patents that you see with patent numbers that if you've ever looked at a patent before. And so it has all the formal requirements, all the drawing fees, and this is much more expensive because of all of that. It has all the claims. And so that being said, the work that we might have put into the provisional is going to reduce the non-provisional costs, because we don't just throw that work away. We're not deleting those words. We're going to use that when we do create the non-provisional, and hopefully it's going to match up as much as possible, so that it looks like the provisional was all completed or that the invention was set in stone as of the filing of the provisional date. So the non-provisional application has these various sections that we alluded to. It's got drawings, it's got the abstract, it's got the background, it's got the summary, it's got the brief description of the drawings, it's got a detailed description of the invention, and then it has the claims. And the claims are the most important part of the invention of a patent document. And all of those other things are designed to make sure that you're informing the public as to what the claims mean. And so what we mean by the claims is claims are I just want to briefly talk about that, just so that we all understand that the claims are what you're getting the monopoly on. So we have to describe in words your inventive concept, and that's what the patent examiner is when we file the patent with the patent office. That's what they're looking at to see, are those claims new? Are they non-obvious over what's out there before? And they use the detailed description and the drawings and the background and all these things to understand the claims. But the claims are really the thing that is what you're getting the protection on. So what do we expect after we file our patent application? We first file the patent application, the non-provisional, I should say. So if we file it provisionally, then nothing happens until we file it non-provisionally. If we file it non-provisionally, it might be a year or more, and we're gonna wait for the United States Patent and Trademark Office before they even look at it. And then we get what's called office actions. There's going to be a later slide where we go into what's called patent prosecution, which is sort of the negotiation with the patent office regarding us on behalf of our clients arguing with the patent office as to why their inventions are novel, meaning new, and not obvious over what's out there. So we have to do those. We have to respond to what the patent office says, and it's not an adversarial process. At least it shouldn't be. And most examiners treat it the way it should be, which is that they are, they're working at the patent office to look at your patent application, and basically they're sort of an arbiter of the threshold of patentability, and they shouldn't be an adversary. You shouldn't be fighting about. You should more be working with them to try to look at what's out there and see what's different about your idea, and that's what's called the patent prosecution process. We'll get into that. But then finally, assuming that a lot of patents that are filed, almost all of them get office actions on the first go round, but eventually most of them still will be worked out where a patent will be granted on an idea. So that's the final step. So during that stage, once you file that, whether it's provisional, or whether you file a design patent, whether you file a non-provisional, all of those, you're patent pending. So during that, you can say you're patent pending. You can put that on product literature, websites, packaging, marketing materials. You want to make sure that you let people know that you're patent pending at that point. And that's going to serve as a deterrent to try to prevent others from, or try to give others the idea that, hey, you got something here, and they don't want to proceed. What can you do though? Can you file an infringement suit while you're patent pending? The answer is no. You're only patent pending. You can't sue somebody. Can you sound a notice letter? Yes, but that's not a cease and desist letter. You can put them on notice that, hey, we're patent pending. We don't have anything yet, but we're in the process. That's basically what a notice letter is. But you can't say we're going to sue you because you don't actually have the patent granted yet until you get it. And that's, after the patent's granted. Can you license a pending patent? Yes, if somebody wants to. And I say that licenses are more likely once the patent is granted, but absolutely, you can absolutely license a patent that's only in the pending stage. Other activities, you can market, you can continue to develop the idea, you can seek investment. And again, at the pending stage, that's something that a lot of investors are going to want to see. And you can disclose the idea to the public, and you can make that public disclosure once you're patent pending, because you are protected at that point. You don't have to worry about the 1-year bar because you've filed, and you've filed within that 1 year. So now, this is what I alluded to. We're going to just talk briefly about patent prosecution, but basically patent prosecution is after you file. You get these back and forths from the patent office where they issue what's called an office action, and 95% of the time, no matter who the applicant is, whether it's we have clients that are some of the biggest filers in the world, and they're getting office actions on the 90%, 95% of their cases, just like the individual inventor. That's just the process. You get an office action where the examiner will examine the claims, and it's not very few. I mean, it happens, but very few, no matter who the client is, are getting an allowance right when they file it, without having that examiner give you an office action, which basically office actions are look at the claims is their primary focus, but also other aspects of the application as well. And certain things might need to be changed, amended, and the focus is really on the claims and the claim language that we've come up with to describe your idea, because that's what the monopoly is granted on, is the claim language. So when you say I claim yada 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 and it has A, B, C, and D, these elements of our claim, and my widget has A, B, C, and D, to infringe the patent, the infringer would have to be doing a widget with A, B, C, and D. Word for word, they'd have to do every single thing about your claim. And so that's why the claims are so important. And that's what's fought over, but argued about it. And we go back and forth again, try not to be adversarial with our examiner that's examining. And the patent office is a campus of hundreds of examiners with many buildings, almost like a college campus down in Alexandria, Virginia. A lot of them are now working remotely, but there's many examiners, and you get assigned an examiner that's related to your art unit. So your art unit being like the type of invention you have. And so your examiner is going to have some familiarity with those types of ideas, because your idea will be categorized and provided to the examiner, an appropriate examiner. Okay. Oh, and I forgot to mention the restriction requirements real quick. Restriction requirements, you're permitted one invention per application, but what that means is if you're an inventive concept, if you have multiple inventive concepts, you may be what's called restricted out, and the examiner may say, hey, you've only paid the government fee for one invention at this time. If you want to have your other inventive concept examined, you have to pay an additional government fee if you do choose to do that, you'll actually result, and it could very well happen where you file the divisional application and you get actually 2 patents off of your initial application instead of 1, because the examiner has identified that there's multiple ideas there. So then finally, assuming everything goes well, you'll get a notice of allowance, which you're then given 3 months to inspect the file and pay the issue fee if everything looks good. Then you get an issue notification where the USPTO informs you when the patent will issue and gives you a patent number. And then the USPTO will send an official ribbon copy, which is a very nice document. People like to make plaques of their first page of their patent as well to display at their corporate headquarters. Oftentimes our clients, and the official ribbon copy is also a nice document. So basically, international protection. When what we talked about just a minute ago is all U.S. related, and I just want to make that distinction that when you file that U.S. patent application, it's getting you the rights to basically a monopoly, the rights to exclude others in the United States. If you want to get the rights to exclude others internationally elsewhere, you have to there is no such thing as a global patent. You have to file your patent application individually in the countries that you want. One thing that you can do to make this process a little bit easier is to file what's called a PCT application, Patent Cooperation Treaty, which is a placeholder application that you have to file within 12 months of the original filing date of your application, of your US application. You have to file a PCT application if you want to go international. And then that gives you an additional 18 months to decide which countries you want to go into. And so that's alternatively, if you don't want to file a PCT, you can directly go into the foreign countries, but you have to pick at the 12-month date which countries you want to go into. Whereas the PCT gives you 18 extra months. Oftentimes, especially with startups and small clients, it's better to get those 18 extra months to decide which countries and whether it's worth it. Because every country you go into, we sort of gave you the quote for the 10 to 30,000 for a US patent all the way through both the application process and the negotiation with the patent office and the maintenance fees. Each country that you go into, it varies, but it's thousands of dollars per country. And so there's certain sort of the European Union has a European patent, but basically, most major countries. And so what we see with even our biggest clients is that they're picking and choosing which countries they want to go into, even with their most important ideas. They're picking their biggest markets. So now you've got your patent, you can file infringement lawsuits, you can send cease and desist letters, not just notice letters. You can mark you need to mark the product with a patent number to put everybody on notice. These are things that you can do now you have your patent. You can also sell the patent. You can license the patent, as I alluded to earlier. It's going to be a lot easier to find licensors. I found after you get the patent versus when it's pending, although it is possible when it's pending. You can sell the product. It opens up a lot of doors once you have that patent. And then you also can continue to develop and innovate and try to file new patents on improvements, because your patent will expire in 20 years. And sometimes companies that are going well don't really think about that, and then their patents expire, and then they're looking at what are they going to do now. Okay. And so I'm going to now, I think I'm going to turn this over to Allie to talk about the Allie Scoville is also an attorney from our office of Schmeiser, Olsen Watts, and she is going to talk about both trade secrets and trademarks.
Thanks. Hi, everyone. Thank you for attending today. So my name is Allie Scoville. I'm also an attorney at Schmeiser, Olsen Watts. I specialize in trademarks and also do work with various other intellectual property. So let's jump right in with trade secrets. So like Vic alluded to in his presentation, if we're thinking about patents, the idea is you're disclosing your idea, and in return for disclosing your idea, you're getting that 20-year monopoly. On the trade secret side, the goal here is actually to keep whatever the idea is, whether it's a recipe, whether it's source code, identifying what that is and maintaining its secrecy. The benefit comes from that secrecy. So this secrecy can last forever. So Coca-Cola has had its proprietary recipe for its drink. KFC has had its proprietary recipe for however many years. As long as they are able to keep that secret, their protection exists there, because no one else knows what that recipe is, or, in the case of source code, no one knows what in particular that source code is. Again, this is a much lower cost form of IP to protect. There's no filing costs or maintenance fees. Again, we're not making any filings disclosing what these trade secrets are. We're keeping them a secret. So what we want to identify when we're looking at whether to protect something through trade secret is this something that can be kept a secret? If I have a mechanical product that I'm selling into the market, if it's possible to reverse engineer that product or independently develop it, it might be more strategically sensible to seek patent protection for it so that I can prevent other people from reverse engineering. If it's something, however, like source code, a customer list, data, algorithms, recipes, chemical formulas, etc., those are things that I will be probably using in my business. They might be a component of a product that I'm selling to customers, but not accessible by customers or third parties. And my ability to keep those things secret is what I want to identify. So some trade secret examples, again, we mentioned the KFC recipe, the nooks and crannies of the Thomas's English muffins. That's something that they market a lot. No one knows exactly what goes into it that causes that aspect of their product. We have the Coca-Cola recipe, and we also have Google's search engine software. So those are all examples of trade secrets. So making a switch to trademarks. So when we're talking about trademarks, we're talking about, like Tim said, brand names. We're talking about logos. We're talking about slogans. So this is the federal statute defining what a trade secret is. So any word, name, symbol, device, or combination thereof used by a person to identify and distinguish his or her goods or services and to indicate the source of those goods and services. So what we're looking at with a trademark is, again, this can be a name, this can be a picture like we're seeing on the slide now, it can be a combination of words and designs, and it could also be a slogan. And these are all things that we as consumers in the marketplace use to distinguish between sources of goods and services. So these are examples of word marks or standard character marks. These are generally the most broadest form of trademark protection if you're looking to get a federally registered trademark. And the reason for that is when we're looking at a standard character mark, the registration is covering the word itself without regard to the color, the size, the format of the word. So if you have a word mark that has some type of design element to it, and if we go to the next slide, there'll be an example. So for example, Netflix will have several different trademark registrations. They'll have a very broad registration for just the word Netflix without regard to the red color, without regard to that curvature at the bottom of the word. And that will broadly protect any usage of the word Netflix. So if they decide to make their trademark blue, that word mark will still cover it. When we get into marks that include words that are in part distinctive because of the style or the font of the word, that's when we're getting into, like that example, NASCAR, where we have both a word element and a design element. So it could be the color of the words, the way the words appear, or an actual picture that accompanies the words. And those are called composite marks. So a really important consideration that goes into choosing a trademark has to do with the scale of distinctiveness. So on the left-hand side of the scale, we have generic words or generic images. And on the very right-hand side of the scale, we have two similarly strong forms of trademarks called arbitrary and fanciful, and a couple in the middle. So starting on the left-hand side of the spectrum, when we're talking about generic words, these are words or images that can never be registered as trademarks. They would never be treated as trademarks. And the reason for this is because these are words that exactly describe whatever the good or service is. So if I'm a purveyor of doors, I could never use doors as a trademark. I could certainly never get that registered with the USPTO as a federally registered trademark, because that is a word that everyone in the industry uses to identify exactly what that good is. And if I were to have a monopoly on that word or the ability to use that word as a source indicator, I would be severely, that would be a severe negative for any of my competitors, not being able to describe what their goods actually are. So generic words, like if I sell cereal and I'm trying to use cereal as a trademark, that's never going to be treated as a trademark. Moving to the right, we have descriptive marks, and these are kind of a step away from generic in that they're not identifying exactly what the good or service is, but they are describing an ingredient, a quality, a characteristic, function, feature, purpose, or use of the specified goods. So an example of a descriptive good or a descriptive mark would be bubbly if I'm selling bath soap. So it's not identifying exactly what bath soap is, but it's describing an ingredient or characteristic of that product. Now, merely descriptive marks are registrable on the principal register with the USPTO if they have acquired distinctiveness. Acquired distinctiveness can happen over a period of time. So generally after 5 years of use, the USPTO will accept acquired distinctiveness claims with respect to marks. Acquired distinctiveness can also happen through very proactive advertising, substantial advertising expenditures to really put into the consumer's mind the connection between that merely descriptive term and your goods and services. So it's not merely a descriptive term anymore. It is something that consumers in the marketplace are using to identify your goods and services. Moving to the middle of the spectrum on the previous slide, I'll try to get through these last couple pretty quickly. We have suggestive marks. So a suggestive mark is something that requires a little bit of imagination, thought, or perception to reach a conclusion as to the nature of those goods and services. So when the consumer's looking at that mark, they're thinking about your goods and services, there's kind of a step of thought that needs to take place in order for them to understand the significance of your mark. An example of this is Netflix. So net is suggestive of internet, where we're seeing these videos being streamed, and flicks, of course, is a term that people use to refer to movies. So when we combine those two terms together, Netflix, that is suggestive of the goods and services that are being sold. Arbitrary and fanciful marks are the two strongest type of marks. They're the most distinctive. An arbitrary mark is a word such as apple. That is an existing word. It's something that we use in our vernacular, but applied to goods or services that have absolutely nothing to do with that word. So Apple computers, Apple is a real word that exists, but as applied to computers, Apple doesn't describe a quality of computers or identify an aspect thereof. And then on the very end of the spectrum, we have fanciful marks. A fanciful mark is usually a term that has been invented solely for the purpose of functioning as a trademark. So an example of that would be Exxon. Exxon is not an actual word, it is solely a trademark. Other examples of that would be Haagen-Dazs ice cream. I'm fairly certain that Haagen-Dazs doesn't actually have a meaning. And also Xerox would be an example of a fanciful mark. So far we've been talking a lot about federal registration. However, there are protections that exist for trademarks that are being used without a federal registration. So a trademark essentially comes into being the moment you start using it to identify your goods and services, as long as that's not generic, a generic word. And so without federal registration, what we're looking at is common law trademark rights. So you do have rights if you start using your trademark, but don't have federal registration protection. And these rights are enforceable within whatever the geographic area is that you're selling or purveying your goods and services, and in which you're continuously using that trademark. So there are various things that you can do without a federal registration that will help you protect that those common law rights that you have in your mark. Number one is to always use the TM symbol, which stands for trademark, in all of your uses of the trademark. So if you have, let's say you have a composite mark, which is a word, including some design element, you have it on the top of your screen, on your website. You want to make sure that you have the TM symbol there. And also whenever you're describing your mark within the text of your website. Similarly, the goal here is to distinguish your mark whenever you're using it so that it stands out from the other text. And this helps put other people on notice that you're using this as a trademark. So if you have a paragraph and you're describing or advertising your goods and services, you want to bold or capitalize, italicize, or underline your trademark to set it apart from the surrounding text. So if we have a trademark in a snap, these are 3 examples of ways that we could distinguish it. In all examples, we want to use that TM symbol, but we can capitalize it. We can use all capitals, or we can use all capitals and bold. So any combination of that, that's really setting it apart as a trademark. And then similarly, we want to consistently use that trademark, however makes sense for our goods. So if we are selling goods, where someone can order it online or pick it up at a store, we want to use that trademark on the packaging or tags of those goods whenever possible. Alternately, we want to use the mark on the good itself. So if it's a plastic item where the mark can be printed or included or engraved somehow, those are all ways that we can put the trademark on the goods. For services, we're looking to use the trademark on any websites, advertising that we have for those services. And again, always making sure that it's distinct from other text. There are several reasons why it's a good idea to apply for federal registration. Number one, if you have a federal registration, you have several presumptions in your favor, which can be really useful if you're enforcing your mark. So number one, it is presumed that you have a valid trademark with nationwide protection. So what that means is if you have a federal registration and say a small business in California starts using the exact same term for similar goods and services, you can enforce your mark against them, even though maybe your commerce is mainly the Eastern Seaboard. After a certain period of time, 5 years, your mark can also obtain incontestable status that requires the filing of a certain declaration about continuous use of your mark. That status is beneficial because it decreases the available defenses that a potential infringer would be able to use against you in an action where you're trying to enforce your mark. It also makes available statutory damages, which can sometimes be more than your actual damages in an infringement action. And it also gives you the ability to use the R symbol. So when we see the R symbol, that means that a trademark is registered. And the only time that you should be using the R symbol with the circle around it is if you do actually have a registration. So the process for obtaining a federal registration, a little bit similar to the patent process. Number one, you're going to file your application. That application is going to be assigned to an examining attorney. That examining attorney is going to conduct an extensive search, and what they're going to be looking for is any marks that currently exist, any applications for marks that currently exist, any currently registered marks that could be similar to your mark. And if they do find something, or if they determine that your mark is merely descriptive, like we talked about before, in which case your mark would need to show acquired distinctiveness in order to be registered, we're going to get what's also in this instance called office actions. So if we get a likelihood of confusion refusal, there are several legal arguments that we can make to try to overcome that, and those would be in the responses. Once all of the issues that the examining attorney identifies, if any, are resolved, the mark is going to be published for opposition. This is a 30-day period where anyone in the public, whether they have a business or they're a startup, what have you, a large company, they can oppose registration of your mark if they believe that the registration thereof would be negative to them. So if they think that your mark is confusingly similar, they might file an opposition. If there are no oppositions filed during the publication period, the mark will register. If you have filed with a use-based application, meaning you've already started using your mark, at that point, you'll receive your registration certificate. If your mark was filed as an intent to use application, meaning at the time of filing, you had a bona fide intent to use the mark and the mark has been allowed, you'll receive a notice of allowance and you'll have a certain period of time during which to submit what's called a statement of use and a specimen. In the case of a use-based application, you would also be submitting a specimen, and this is to show use. The only way your mark is going to be registered is if you are actually using it and can prove to the patent office that you have indeed been using it. There are maintenance fees associated with having a federal registration. The first one comes up at the 5-year point, and then at the 10-year point and 15-year point, and there are certain declarations of continuous use that are associated with those.
Okay, I'll take it over from you, Allie. Thank you. So, we talked a lot about the forms of intellectual property. I'm sure what's weighing in the back of your minds is the cost associated with receiving protection, particularly with patents and trademarks. What I want to cover now is some areas in which we can you can actually defray, or even eliminate some of those costs and still allow you to enjoy an intellectual property strategy. As a former engineer who worked for 3 different startups, very sensitive to the early days of a company as they're trying to raise funding. And so intellectual property, as we mentioned earlier, is very, very important. And this could be, this could be helpful to you in terms of defraying some of your costs. So as Vic mentioned, the provisional patent application is a very, very powerful way to not just put your line in the sand in terms of where identifying you as the first to invent something, but it can also buy you some time in terms of how to, where you can absorb the cost down the road versus upfront. So at some point, you're going to have to pay Paul, rob Peter and pay Paul in order to receive your patent protection. You could do it up front earlier and then work with an attorney to develop the claims and start working on the prosecution side immediately, or you can defer it by a year. And for many people, that extra year is very, very important as you're trying to raise capital and so forth. So in addition to the cost of preparing an application, much of which, if not all, you could do yourself, there are obviously filing fees associated with that. You know, the U.S. government obviously is going to get its piece of this. Deferred costs. So one thing, as I mentioned before, you could defer the cost of the filing of a formal patent application by 1 year by filing the provisional application. And you can also defer the cost along those lines of formal drawings. You can hand draw drawings for a provisional if you'd like. They don't have to be, you don't have to be an artist to do this. You don't have to be a formal draftsman to file a provisional. But there are very, very strict requirements when you file it, when you convert it to a non-provisional patent application, that it must be adhered to. And so that's something you can buy time on. Foreign applications, same situation. The PCT application, the international application that was mentioned by Vic, you're given another year as well. After you file your application, generally the patent office won't look at it for 1 to 3 years. Much of it depends on the technology and the subject matter. Mechanical related applications I've seen as little as a year. Some of the more complex software applications, some of the biochemical related applications with regard to healthcare and so forth, you know, DNA strains, stem cells, you know, all that technology that I'm not as directly involved with could be up to 3 years or more. Trademark filing could certainly be deferred, as Ali mentioned earlier. You could file a trademark application up front, but at some point you have to associate with a product. And if you don't have a product yet because it hasn't been built or developed, then you can put the TM on the product and move forward from there. So I mentioned deferring costs. So here's how we could actually defray costs and actually save money as opposed to delaying the payment of money. One of the recommendations that many of us patent attorneys offer or recommend our clients is to perform an upfront search to see if there's anything else out there that is similar to what you're considering as your invention. A prior art search would allow you to hire somebody, and you can pay thousands of dollars to do it, and they have these extensive data mining tools to be able to identify, to see if they can find something else out there that's related. And for many people, especially people who are looking at patent protection as being pivotal and critical to their business, they want to be preemptive. And you can do a lot of that yourself. A basic Google search for this is what people often do. The U.S. Patent and Trademark Office also has a search tool as well, and it's a keyword search. So you can be somewhat preemptive up front and save yourself a little bit of money there as well. The provisional patent application, as I mentioned before, you could write the text yourself. And so long as it has enough detail in it to cover the enablement requirement, which enablement basically means that you have to write enough almost like you're writing a product specification. You want to write enough detail so that someone, when they're reviewing it, can make and use the invention. That's the test for enablement. And if you write enough of that detail in it, a lot of that could be handled by the draftsman, and you could file that accordingly. You could save money if you have simple drawings, or they're not, and your invention is not that complicated or if it's a software related application. General flow charts would be acceptable. You could save yourself the cost of a draftsman. Obviously, you want to have clear communication lines with the patent attorney. The more you speak to an attorney, the more you're going to pay. I mean, that's true of any form of law. And if you're clear up front and you're articulate in terms of what you're describing to the attorney, then that can actually defray the cost as well. With regard to the claims, broader is better. So basically, as Vic mentioned, the claims, they're almost like when you're dealing, we call it intellectual property for a reason, right? Intellectual property, if you compare it to regular property, you have your nice house and you have your picket fence and you have the no trespassing sign that surrounds your lawn, on your lawn, that basically tells your neighbor, stay off my property. That's what claims are. Your claims is that no trespassing sign. And if you try to go beyond your allowed property, other people are going to go onto your property. It's not even your property at that point. It's fair game to anybody. So when the broader the claims are, the easier it is for those claims to be attacked. And so the point of this bullet point here is that if you narrow the claims to the point where it focuses on your specific invention, the patent examiner is less likely to find something else to attack you on when it comes time to trying to enforce and argue why you're the first to invent whatever the invention is. And then obviously, as Ali mentioned earlier, trade secrets are an option. So IP strategy, we talked about costs, we talked about how to save money. In terms of tying this into your IP strategy, one approach is to file what's called an omnibus provisional, where you may have many different ideas. You may have one product. Let's say it's a physical product, and you have all these different ideas, and each one to you is important, and each one to you is a potential invention. You can file all those under a single application. It would be, eventually it's going to have to be identified as one invention per patent application, but up front you could file that as a provisional application and get that on file. And you can build over it over a year as you start to come up with improvements. As I mentioned before, you could perform your own initial search just to see if it's even worthwhile to consider a patent. And you certainly want to identify yourself as being the owner of that property. So under US patent law, the inventors are initially the owners, but they, in companies, regardless whether it's LLC or it's an incorporated company, are often asked to assign their rights over to an entity, to the corporation itself. And investors will be looking for that as well. If you have employees who invented intellectual property, you want to make sure that that's captured under your entity status. And then, as Vic mentioned earlier, you certainly want to keep the invention confidential until after the patent application is filed. And then, in the meantime, if you do have a trademark that is going to be tied to something, you can add the TM to it up front. So we've laid out a very high level strategy. As I mentioned right at the beginning, each of you will have your own unique needs and interests. And if you want to drill down on that a little bit more, we do offer initial consultations. And so by all means, the door is open to reach out to us at any time. So thank you for your time today. And if you have any questions, again, please feel free to come out and reach out to us.
Good. Thank you. Thank you, all of you. If anyone has any questions they want to add into the chat, Rachel can go through those. And
Okay, I have some questions right now. The first question, is it feasible to file patents without a patent attorney? And if so, what is the rough cost to do so?
Vic, I guess I can handle this. So the short answer is you could file a patent application without a patent attorney. Many people do. They'll file a provisional. I showed a cost earlier. It's a $150 filing fee. You can prepare it, you convert it to a PDF, and you upload it into at the USPTO website. Without an attorney, it's really incumbent upon you to make sure that when you file, you have exactly 1 year to the day that you file it to convert it. And what people will often do is they'll wait until the 10-month date or the 11th month date, and then all of a sudden they'll produce a napkin with some scribble on it, and they'll say, I filed this with the patent office. And then we are burning the midnight oil to try to convert it to that non-provisional so that it passes muster with the patent office. But the short answer is yes, you can file it on your own, and the cost is $150.
I'll just add, I think just to be clear too, just to add on what Tim's saying is, the provisional is what, I mean, you definitely want to make sure you do description, enable it and all that with your provisional filing. And we have, inventors can do that on their own. It's not always, you definitely want to spend some time looking into the best way of doing it. But what Tim is alluding to, and I think it wasn't, is that you don't want to do the non-provisional on your own. Okay. That is not something that you want to do on your own. You're gonna create not just more costs if you try to do that, but you're also likely to lose your IP in many ways because of losing the quality of the IP if you do it on your own. The provisional would be the only one.
Yeah, exactly. I had a client a couple of years ago, and it was a very short-term client. That's exactly what happened. They filed the provisional, they find the non-provisional. They actually, the examiner reviewed it, rejected the application initially, and the client tried to argue with the examiner to argue why it was a patent. And the only thing that the client could do, and then finally the client called me, and by then the client had already, basically it was a calculator, and it was a special financial calculator, and the claim, there was one claim to it, and it described each button of the calculator and each function. So the claim itself was 15 pages long, and I'm not exaggerating. It was completely useless to the client. And then the client tried, by the time the client called me, they wanted to sue everybody, every calculator manufacturer, but the claim itself was so narrow that it was completely useless. The client had just wasted time and effort, and my time, to try to unravel it.
Okay, the next question. What are relevant considerations when considering patent applications for software?
I can handle that as well. I handle the bulk of of our office's software applications, so I see a lot of most of my work actually is software based. Software, it's not tangible like something, like something that's mechanical, and it's not physical, but the general concept of a patent is patentable. There's been some recent laws that have passed, and this might be where the question's coming from, that has made it more difficult to receive protection for certain types of software. And I'll give you an example. What is not patentable anymore is if somebody tries to file a patent application for a method of improving a baseball swing, or something that would normally be performed by a computer anyway. The general rule of thumb is is that the invention should provide a technical solution to a technical problem. So many, and if not most, patents today that are software-based are improvements from existing something that's existing software, some existing computer or networking related innovation. That is acceptable. If you're trying, case in point would be if you're trying to improve the performance of a computer, or you want to improve the speed in which a record is added to a database, or if you want to improve the computer security, things along those lines, those are patentable. But if it's an abstract type of concept, the simplest one is the improving the baseball swing, or a method of performing a calculation for something. That is going to be more difficult. But software is patentable. Did I answer the question?
Yeah, I think so. And also, it's like if it's something that a human could just do, and you just or do in their head, or just do like Tim's examples, it's going to be less, and all you're doing is saying, I'm going to write software so a computer does it instead of a human, and it's a simple thing that a human would otherwise do. That and you're not doing anything new with the computer, you're not improving anything. Then that's not going to fly as much as it with the more recent case law.
Right.
Okay, next question. What forms of IP protection are best for a computer or mobile application?
Do you want to take that, Vic? Or do you want
same line, along the same lines. The patent, if it's new and it's not been done before, and there's something that's novel and isn't just applying a computer to do something that would otherwise have been done like a simple calculation by hand or whatnot by an accountant, and you're just having a computer do it, then it is actually like something that hasn't been done before in a software realm, then definitely patent protection. Otherwise, you are able to have certain protections in your actual source code itself, and you want to try to protect that as much as possible by both keeping it as secret as possible, possibly if there's ways in which you can make sure that the people that are users don't have access to your source code. That might maintain trade secrecy on your software. It is also, you want to embedded within your code, you can also put copyrights. So C with your name and the year, or the name of the owner and the year, as far as that's giving you copyright protection, which we haven't really touched on, but that's the creative expression of there might be, your code might do lots of different things from a utilities perspective, but there's also a certain amount of creativity, because if you're developing software, you might do it in a different way than another person, even if two software developers are asked to develop a software that does the exact same thing, and the creative expression of one of those developers might be different than the other. So you can sort of also protect your code in that way as well, by embedding it and trying to make sure that people know that they can't just copy and paste your source code. If you don't have the patent though, and you aren't eligible, or you choose not to do the patent protection, then somebody else can take the software concept, the underlying idea, and they can develop their own code to essentially compete against you. But they won't. What the copyrights and the trade secrets do is that sort of prevents others from either hacking in and trying to attain your source code illegally and then just copying it and using it. Or in the copyright is the same idea, is the copyright's going to prevent others from, even if you legally allow them to see the code, if you copyright it, then they can't just copy and paste it for their own commercial use. But they could write it themselves and write a new code themselves. If you don't have patent protection, then they can write their own version of it without really looking at yours, and just looking at how yours works on an overarching, from a user perspective, and try to design around, or try to come up with their own version of it. Patents would protect that, of course.
Okay, this is a multi-part question. In your experience, what happens when a cash-constrained startup gets infringed upon by a larger, more resource-rich company? Any suggestions on how to defend effectively without losing focus and expending lots of money? And can you give an example from your experience?
You want to take that, Vic?
Yeah, sure. So it was, just read the first part of the question again real quick.
Sure. In your experience, what happens when a cash constrained startup gets infringed upon by a larger, more resource-rich company?
Right. So, okay. So, right. So this is sort of the situation where you have your patent. You've done you've done the best you can do as a small, like you said, cash constrained company, and you've tried to deter competitors. You've done all of your you've done everything you can do from protecting your IP, and then somebody goes ahead and infringes it anyways. So there's you're definitely it is sort of a game where money the amount of resources that you have matters in the legal world, and so that sort of can be a problem, but depending on it's sort of a game of leverage, and in that situation between yourself and this competitor that might be bigger than you, and the patent is the only leverage you have. The leverage that they have is their financial resources, but the patent is the only leverage you have in that situation. And it is a decent amount of leverage, even though it does take money. But depending on the strength of the patent, depending on the strength of your case, there are avenues in which you can assert the leverage that you do have, which is your patent, by either there are people that fund these types of litigations, infringement suits that would be, if you have a good patent and a good case and a compelling story, that they would come in and of course they're going to take some of the proceeds if you win, but they would help in your situation fund that. We've had our smaller clients try to assert against larger entities using that approach, or you just see where when you try to assert against that bigger entity, you have to realize that their leverage is in the money that they have. And so the goal is working with an attorney in those situations that has sort of a cool head on their shoulders, so that you can work out a favorable deal with them in that situation, where instead of just saying, oh, we have to sue them, trying to approach them, trying to work out, and even though you're not going to tell them that we understand that you have leverage because you're bigger than us, but you still coming at it from that perspective that litigation might not be the number one avenue to go in that situation. Perhaps licensing, perhaps trying to set up a deal that wouldn't arise. Now, sometimes that doesn't always work. But at least it's a start to try to, and then in terms of even settlement, if you have to sue, and how long you want to go into a lawsuit, and once the suit starts, if you have to go to a litigation approach, it's also recognizing where you're at from a settlement perspective, and the leverage. But it's all about leverage, and the only leverage that you have is the IP in that situation, big versus little.
Yeah, I can actually speak to part two of that, which is a personal example. I actually have a client now. I was on the phone with him last week recently, and he's involved in it's a piece of software that he has, and it's in a multi-billion-dollar industry. And there are many multi-million-dollar companies, industry leaders, who are infringing his patent. He filed it 10 years ago. We've gone through one thing that we performed was an initial exercise to see if we had legs against them, to make sure that they didn't file first. We talked about the importance of first to file. And so he's in a situation right now where he's a startup. He's limited means, and what he did very smartly was he filed the initial provisional patent application years ago, but he piggybacked, after he filed the initial application, he piggybacked it by what's called continuation applications, which are new applications filed with the patent office, but it's the same drawings and it's the same disclosure of the original application, but the claims are different. And it's a very, very important, a very powerful strategy. And he kept filing continuation and left them open. So, and we could talk about this forever, but basically there's a strategy where you can actually tweak the claims in one of these continuation applications to actually disclose or read what the infringer is doing. And when you do that, you have another angle of attack from which to enforce your patents. And so he's doing that, and and it's fairly inexpensive for him on that particular part. The expensive part would come in if he had to bring it to court. And he's hoping he doesn't have to do that. But as Vic mentioned, he's actually working with people to on a very favorable cost basis, to allow him to protect his patent. It gets basically an industry.
Yeah, and so there's litigation funders and there's also
Yeah.
law firms that work on contingent fee.
Right.
They both essentially work in a similar way from a client perspective, in which case you're giving up a certain percentage of whatever the proceeds
Right.
would be on the case to have them, to not have you have to pay the legal fees of that. But all that depends on the circumstances, how strong your patent is, how much money we're talking about in terms of the value of the infringement, et cetera.
Yep.
Okay, that's all I got for questions.
Okay, they were all very good questions. Thanks for presenting them to us.
Well, thank you everybody for joining us today. I did put a note in the chat, and if you were interested in the recording, you can email me and I'll send you a link to that. And again, thank you. Hope everyone has a great rest of their day.
Yeah, have a good day. Thank you.
Great, thanks guys.
Thank you.
Thank you.